Now, yesterday, Bruce Lehrmann's defamation case against Network 10 failed after Federal Court Justice Michael Lee found that on the balance of probabilities, he had raped Brittany Higgins in Parliament House in 2019. That meant that Network 10's truth defence was validated. Well, for more on this now, I'm happy to say I'm joined by a former judge of the New South Wales Court of Appeal and chair of the Centre for Public Integrity, Anthony Weirley. Anthony, thank you so much for coming into the studio.
A pleasure, James.
It's often been said that defamation law in this country has limited the ability of the media. Does this case change that at all? Does this have, is there a possibility that people are going to think twice now about taking defamation action?
Well, I think this case emphasises the effectiveness of the truth defence. It also, of course, demonstrates that there's another defence available even where truth is not established, and that's what's called qualified privilege. But to explain that, it just means simply that the media outlet has to show that it has acted reasonably and therefore in the public interest.
Are you broadly of the view that defamation laws in this country still do need changes? Because occasionally we see media outlets decide to settle a case just simply to avoid the very, very high cost of going to a trial.
Yes, I do think that there's always room for improvement in our defamation laws. They're always under attack. It's interesting that the plaintiffs say it's so hard to win and the defendants say we always lose. But I don't think either of those statements is entirely accurate, but there's no doubt the media has had cause for complaint in the past about the stringency of the defamation laws.
Well, let's go to yesterday's decision in the case. The legal fees in this seem very likely to run into the millions of dollars. Do you expect, on what you heard yesterday, that Bruce Lehrmann is likely to appeal, and does he have an obvious avenue to do so?
I think that myself, that he probably will appeal. I think that looking at the judgment as a whole, although it's very well structured, when it comes down to the critical point of whether a rape occurred, there were three things the judge analysed quickly. He said, one, did sexual intercourse occur? Yes. Well, that seems to be something that almost impossible for any appeal to overturn. But the next two issues I think are problematic. Did Brittany consent? And did Bruce Lehrmann know that she was not consenting if she did not? Those two areas are quite difficult for the judge to have reached the conclusion he did, and I think there is scope for an appeal on those 2 points.
So it might not be finished just yet?
I don't think so, because the amount of money involved in the cost is so large that one would think the cost of running the appeal would be dwarfed by the it would dwarf, by comparison with the cost of running the trial.
Now, of course, in this saga, a criminal trial was abandoned in the ACT due to juror misconduct, and this was a civil trial. Justice Lee stressed that repeatedly throughout, and of course again yesterday. Apart from the possibility of that appeal, presumably another criminal trial in this is extremely unlikely.
I don't think it's possible. I mean, It's been abandoned. The criminal proceedings were totally abandoned. It's not possible for another prosecution in this case to be brought.
Okay. And finally, Anthony, I wanted to ask, this is a much less consequential question, but yesterday's 324-page judgment was marked by some particularly wry observation. There were some comments about lions' dens and hats, and the word omnishambles was used. What's your view on a judge using those sorts of phrases? Are they the mark of a frustrated actor or author, or do you think this language just simply helps convey the meaning of a judgment to the wider community and avoiding otherwise pretty dry legal language?
Yeah, well, I'm conscious of the fact there's been some criticism of the judge throughout the trial for some of his language and light-hearted remarks at times, but it doesn't hurt, I think, occasionally in a difficult trial for there to be a small bit of light-heartedness. It eases the temperature. But coming to his judgment, I think myself that anything that makes the judgment more readable, more comprehensible, more understandable for the general public is a good thing. So if the language used in this case has that effect, as I think it does, then I would commend the use of that language.
And just very lastly, I promise this is my final question, the power of a live broadcast to deliver a judgment in that way, what's the impact? I think there might have been 45,000 people watching it on YouTube.
I think it's terrific. Even years ago when I was a judge doing the terrorism trials, we did broadcast the sentencing, which was quite long. I think one took 4 or 5 hours. So it's a bit of a marathon for people to watch, but they like to watch it. And I think anything that makes the courts more accessible to the public is a good thing.
All right, Anthony Whealy, thank you so much for speaking to ABC News.
A pleasure, James.